The teller at Coastal Western Bank had been working the counter for 4 years. And in those 4 years, she had learned to read the lobby the way you learn to read any room you spend 40 hours a week inside. By the small signals. Who was nervous? Who was confused? Who was going to need a manager? The old man who walked in on a Tuesday morning in March did not look like any of those categories. He was 72 years old, though Sandra Oaks could not have known that from looking at him. He wore a clean flannel shirt, faded at the elbows, and work pants that had been washed so many times, the color had settled into something between gray and brown. His boots had been polished. They were still boots. He carried a brown envelope under one arm and walked directly to the counter without looking around. First, the way people walk to places they have been to many times before. His name was Walter Briggs. He had kept an account at this branch since 1987. Through 2 name changes and 1 full ownership transfer, the building at the corner of Elm and Covington in Fresno had held his money, and he had come to it the way a man comes to any tool he trusts, without ceremony, without expectation of surprise. He set his account card on the counter. Sandra pulled up his file. Checking account, savings account, both active. The savings balance was $4,000 and change. He said he would like to withdraw $600. The repairman for the irrigation pump on the east section did not take cards, and Walter had learned a long time ago not to argue with men who fix things you could not fix yourself. Sandra typed. She looked at her screen. She looked at it again. She said, "Mr. Briggs, it looks like there is a hold on your savings account." Walter said, "What kind of hold?" She said, "A review hold. It was placed last week by our compliance department. I'm going to need to get my manager." Walter said, "Why was it placed?" She said, "I don't have that information." "Let me get Greg." Greg Farrell was 36 years old and had been managing this branch for 14 months. He had a way of walking toward difficult situations that communicated competence before he opened his mouth. Shoulders back, pace measured. The expression of a man who had handled things before and expected to handle this one the same way. He came to the counter. He said, "Mr. Briggs, I'm Greg Farrell. I understand there's a question about your account." Walter said, "There is a hold. I want to know why." Greg said, "Let me pull this up." He typed. He read. He said, "It looks like the hold was placed as part of a routine account review. It is precautionary while we verify some documentation related to account ownership." Walter said, "I have had this account for 37 years. Greg said, "I understand that, sir. This is a procedural matter. It may take a few business days to resolve." Walter looked at him, not with anger, with something more durable than anger. He said, "I drove 40 minutes to get here. I have $600 I need for a repair that cannot wait. A few business days is not an answer I can use." Greg said, "Mr. Briggs, I hear you, but my hands are tied by the review process." Walter had dealt with that phrase before. Hands are tied. He had heard it from irrigation district clerks and county planning offices and one insurance adjuster who had been wrong about his policy and had hoped that procedural language would eventually make Walter go away. Walter did not go away from things that were his. He reached into the brown envelope. He laid the document on the counter. It was a trust deed. The paper was not brittle, but it had the particular weight of something that had been handled carefully for a long time. It was dated September 4th, 1970. The property described in it was 812 acres of agricultural land in Fresno County, California. The grantor was Harlan Briggs. The trustee was Walter Briggs. The beneficiaries were listed as Walter's sons to be named upon their birth, with the trust passing to them upon Walter's death without probate. At the bottom of the first page in the margin notation added by a property attorney in 2022, when Walter had finally hired someone to review the document, was a figure. Current estimated market value based on comparable agricultural sales in Fresno County. The number was $6.2 million. Greg Farrell read the first page. He stopped. He read it again. He looked up at the old man in the flannel shirt. Walter said I would like my $600. Greg did not release the hold. He told Walter he needed to consult with the regional office and that he would be in touch within 2 business days. He gave Walter his direct line. His hand was not entirely steady when he wrote the number down. Walter folded the paper and put it in his shirt pocket and walked out of the branch the same way he had walked in. Directly, without looking around. In the parking lot, he sat in his truck for a moment. The engine ticked in the cold morning air. He looked at the building. 37 years he had brought his money to that address. Almond checks in good years. Operating account transfers in lean ones. He had trusted the institution the way you trust a utility, not with affection, with the expectation that it would function. He started the truck and drove home. The land that Walter was driving back to had been in the Briggs family for 95 years. Harlan Briggs had arrived in Fresno County in the spring of 1929 from a parish outside Shreveport, Louisiana, where his family had sharecropped cotton on land they would never own. He was 33 years old. He came with $200 in a canvas pouch sewn into the lining of his coat, a knowledge of irrigation that he had built from years of managing water on ground that flooded and dried in cycles no almanac could predict, and the particular stubbornness of a man who has watched other men own things and decided he would be one of them before he died. He found work on a large almond operation near Clovis. He spent 2 years watching. He watched the owner manage water distribution across terraced fields. He watched the seasonal rhythms, the dry summers and the cold, wet winters, and he filed what he observed the way a man files things he knows he will use. He lived cheaply. He saved everything above what he needed to eat and sleep. In the spring of 1931, a smaller adjacent parcel came available. The owner had died of a stroke the previous October, and his widow wanted to be closer to her daughter in Sacramento. The land was 812 acres of deep alluvial loam in the lower San Joaquin Valley, the kind of soil that rewarded careful irrigation with yields that surprised people who had not studied it. The asking price was $9,000. Harlan paid $8,500. He borrowed the remaining $500 from a cousin in Baton Rouge and paid it back before the year was out. He spent the next 2 years not planting anything. He walked the land in every season. He dug test wells in 11 locations, mapping the behavior of the water table across the full 812 acres. In 1931, after he had finished his mapping, he went to the Fresno County Water District office with a hand-drawn diagram of the underground aquifer network beneath his property. The district engineer had never seen a private farmer come in with documentation like that. Most men just dug where they thought water might be and argued about it later. Harlan spread his diagram on the table and explained what he had found. The aquifer beneath his land connected to a deeper formation that the district had been trying to access for 2 years to serve the Eastern Valley communities. Harlan proposed a joint agreement. He would dedicate the drilling access and surface rights on the northeast corner of his property to the district's development project. In exchange, the district would formalize his water rights as priority number 3 in the county system, meaning his land had guaranteed access to aquifer water behind only 2 municipal users. The district signed the agreement on March 14, 1931. The agreement contained a clause that the district's engineer had insisted upon. If the Briggs property were ever transferred through means other than voluntary sale or inheritance, specifically through foreclosure, seizure, or court-ordered conveyance, the water rights would revert automatically to the county, rather than transfer with the land. The engineer's reasoning was straightforward. The district had granted priority status to Harlan Briggs because Harlan Briggs had done the scientific work that made the agreement possible. That trust was personal. It did not transfer to a bank or a corporation that had acquired the land through pressure. Harlan had agreed to the clause without hesitation. He did not plan to lose his land. He planted almonds in 1934. By 1945, the year Walter was born, in the back bedroom of the farmhouse on a cold February morning, the orchard was in its second decade of production, and the Briggs land was known in the county as one of the most consistently yielding almond operations in the valley. Walter had grown up understanding the land the way farm children understand the crop of their childhood, not as an abstraction but as a particular work of particular days. He learned to read the canopy for water stress before the leaves showed visible signs. He learned the hull split timing that told you when to call the harvest crew. He learned the irrigation calibrations that Harlan had built from his Louisiana water knowledge, and he extended them with his own observations over 50 years of walking the same rows his grandfather had planted. He had decided when he was 17 that he was not going to leave. His mother had expected him to go to Fresno State. His high school guidance counselor had written him a recommendation for the agriculture program. Walter had read the letter, thanked the man, and gone back to the east section to finish setting the irrigation gates for the season. Harlan had understood without being told. In the fall of 1970, when Walter was 18 and had been working full-time on the land for a year, Harlan called him into the kitchen one evening after dinner. The trust deed was on the table. An attorney in Fresno had drawn it up that morning. Harlan was 74 years old. He sat across the table from his grandson with his hands flat on the surface the way he sat when he was being deliberate. He said, "I have put the land in trust. You are the trustee. When you have sons, they are the beneficiaries. The land goes to them when you are gone without going through the courts." Walter said, "Why now?" Harlan said, "Because you are staying, and because I have watched 3 families in this county lose land in probate that they built over generations. The courts and the banks and the lawyers take their portion. I am not going to let that happen to this." He pushed the deed across the table. He said, "I came from Louisiana with $200 and a knowledge of water. I built this. Your father worked it. You are working it now. When I am gone, I want this land to stay in the hands of people who know what it is, not in the hands of people who only know what it is worth." Walter had taken the deed. He had looked at it for a long time without saying anything. Then he had put it in the tin box on the kitchen shelf. The tin box was green with a small dent on the left side from a time Harlan had dropped it, moving it to a new shelf in 1958. It had a simple latch, not a lock. Harlan had said, "That is where it lives." Walter had kept it there for 54 years. Harlan died in 1981 at 85 years old. Walter's father had died in 1968 before Walter took over full management of the land. Walter had been running the operation alone since he was 32. He had married in 1978. Nathan was born in 1980, Joel in 1983. His wife, Margaret, had died of cancer 8 years ago, and Walter had continued getting up before sunrise and walking the rows the way he always had, because the land did not pause for grief, and because the work was the thing that kept him level. Nathan was a civil engineer in Sacramento. Joel lived 20 minutes from the farm and worked as a diesel mechanic. Both sons knew the land. Both had worked it as boys. Neither had stayed, and Walter had not pushed them to. He understood that the land did not require everyone to stay. It required someone to stay. He was the one who had stayed. He called Nathan that Tuesday evening after he got back from the bank. He said, "They put a hold on the savings account. would not tell me why. I showed them the trust deed, and the manager looked like someone had walked across his grave. Nathan said, "What kind of hold?" Walter said, "They called it an ownership review. Said it would take a few business days." "I have had that account for 37 years. Nathan said, "Did they say what triggered it?" Walter said, "No." Nathan said, "Did they put anything in writing?" Walter said, "There was a letter last week. I thought it was routine. It said, account review section, something of their policy. I kept it." Nathan said, "Read it to me." Walter found the letter on the kitchen table where he had left it after opening it, and deciding it was bank bureaucracy. He read it. It cited a section of Coastal Western Bank's account review policy regarding accounts flagged for trust or estate ownership verification. The language was precise and uninformative simultaneously, which Nathan recognized as the language of institutions that want to appear transparent while disclosing nothing. Nathan said, "Someone flagged your account for trust ownership verification on a 37-year account." Walter said, "Yes." Nathan said, "I am coming down Saturday." Walter said, "You do not need to make a trip for this." Nathan said, "I am coming Saturday." After he hung up, Walter sat at the kitchen table for a while. The tin box was on the shelf where it had been since 1970. He looked at it. He thought about Harlan at this same table in the fall of that year, hands flat on the surface, the trust deed between them. He thought about what Harlan had said. The courts and the banks and the lawyers take their portion. I am not going to let that happen to this. He got up and went to bed. He had a full day of work tomorrow. Nathan arrived Saturday morning and sat across from Greg Farrell in the small conference room off the lobby of the Coastal Western branch. He had the trust deed, Walter's account records going back 15 years, and a copy of Harlan's death certificate from 1981, which he had pulled from the county records online on the drive down. He had also brought the 2022 property assessment that Walter's attorney had completed, showing current estimated market value. Nathan was 44 years old and had spent 20 years building structures that had to hold weight. He had a particular quality that civil engineers develop, which is the ability to locate the exact point where a system is failing without becoming emotional about it. He used it now. He set the documents on the table. He said, "My father has held this account since 1987. He has never missed a payment, bounced a check, or had a dispute with this bank. Can you tell me specifically what triggered the ownership review?" Greg said, "The review was initiated by our compliance department. I do not have access to the specific triggering criteria." Nathan said, "Is there someone in compliance I can speak with?" Greg said, "I can arrange a call with our regional compliance officer, but I want to tell you something first." He paused. He looked like a man who had realized sometime between their first conversation and this one that the situation in front of him was larger than his authority to manage. He said, "I referred this to our regional office. There are questions about the trust deed that need to be resolved at a level above mine." Nathan said, "What questions?" Greg said, "The trust deed predates certain documentation requirements that are now standard under California trust law. Our compliance team needs to verify the instrument meets current standards." Nathan said, "The deed was executed by a licensed California attorney and recorded with the Fresno County Recorder in 1970. It has been on record for 54 years. Are you questioning its validity?" Greg did not answer that directly. He said the regional compliance officer would be in touch within 2 business days. Nathan drove home to Sacramento that afternoon. He called Joel on the way. Joel said, "What do they want?" Nathan said, "I do not know yet, but someone above the branch level is involved." Joel was quiet for a moment. He said, "Is Dad okay?" Nathan said, "Dad is fine. He went to walk the east section this morning like it was any other day. The compliance officer's name was Angela Carver, and she called Nathan on the following Wednesday. She told him the 1970 trust deed was valid. It had been properly executed, properly recorded, continuously operative. She was authorizing the release of the hold that afternoon. Nathan said what triggered it in the first place. There was a pause that lasted long enough for Nathan to understand that the pause itself was information. Angela said during a 2022 internal review, an automated system flagged accounts associated with trust instruments where the original grantor was deceased. Nathan said Harlan Briggs died in 1981. The flag should have triggered then, if it was going to trigger at all. She said the flag was placed in 2022 by our trust department as part of a portfolio review. It was not acted upon at the time. A system update last month caused it to activate. Nathan said, "So someone in your trust department reviewed my father's account in 2022 and flagged it, and then nothing happened for 2 years until last month." She said, "That is accurate." Nathan said, "Why was someone in your trust department reviewing my father's account in 2022? Another pause. She said, "I am looking into that. Can I call you back by Friday?" Nathan said yes. He hung up and sat for a while in his car, in the parking structure of his office building in Sacramento. He thought about what the 2022 flag meant. Not the automated system update that had activated it. The original flag. Someone in the trust department had looked at a 37-year-old account associated with an agricultural trust, noted the age of the living trustee, and done something with that information 2 years ago. He called Carol Ewan. Carol was 55 years old, a trust and estate attorney in Sacramento, who had spent 30 years working cases involving financial institution misconduct. Nathan had used her once before on a water easement matter. He trusted her precision. He described the situation. She listened without interrupting. When he finished, she said, "Nathan, do not accept the hold release as a resolution. The hold release is what they want you to accept. The question is what happened in 2022. Nathan said, "That is what I think." Carol said, "Let me know what Angela Carver tells you on Friday. Do not sign anything before we talk." Angela called back on Friday afternoon. She said, "Nathan, I found something." Nathan pulled into a parking lot and stopped the car. She said, "In 2022, someone in our trust department initiated a property assessment request to the Fresno County Assessor's Office. The request was made under the heading of an estate proceeding review. Nathan said, "My father was alive in 2022. He is alive now." She said, "Yes." He said, "An estate proceeding implies the trustee is deceased." She said, "I understand that." He said, "So someone in your trust department filed a request with the county assessor framing my living father's property as being in estate proceedings." She said, "That is what the documentation shows." Nathan said, "Who initiated it?" There was a long pause. Angela said, "The request was initiated by our Vice President of Trust Administration. His name is Preston Vance." Nathan did not respond immediately. He looked through the windshield at the parking lot. A woman was loading groceries into a minivan. An old man was walking slowly toward the entrance of a hardware store with a list in his hand. He said, "What did Vance do with the assessment results?" She said, "The assessment placed a current market value on the Briggs property. That assessment was filed internally. Vance left our San Francisco office briefly in late 2022 on a personal leave returned, and the file sat in the trust department records." Nathan said, "Angela, I need everything in writing. Every action taken on my father's account from 2022 to now. Every access log. Every document. I need it by Monday." She said, "I will have it to you." He called Carol Ewan back immediately. Carol said, "If Vance filed an estate proceeding request with the county while your father was alive, that is not a procedural error. That is unauthorized conduct against a living person's property rights." Nathan said, "There may be more to it." Carol said, "There always is. Tell me everything." He told her about the 1970 trust deed. He told her about Harlan and the water rights agreement from 1931 that was stored with the deed in the tin box. He had not looked at it himself yet. He was describing it from memory of what Walter had told him years ago. Carol was quiet for a moment. She said, "The water rights agreement. Do you know the specific terms?" Nathan said, "Priority number 3 in Fresno County. Harlan negotiated it in exchange for drilling access on the northeast corner." Carol said, "Does the agreement have a transfer clause?" Nathan said, "My father mentioned a clause about what happens if the land is ever taken by force. I do not remember the exact language." Carol said, "Nathan, I need you to get me a copy of that water rights agreement before Monday." Nathan called Walter that evening. He explained what Angela had told him about Preston Vance and the 2022 estate assessment. Walter listened without interrupting. When Nathan finished, Walter was quiet for a moment. He said, "They were preparing for when I died." Nathan said, "That is what it looks like." Walter said, "So they could manage the estate, collect the fees." Nathan said, "Yes, but there may be something more to it. I need to see everything in that tin box, the trust deed and whatever else is in there." Walter said, "Come Sunday. I will have it out on the table." He hung up the phone and sat in the kitchen. The tin box was on the shelf where it had always been. The same green paint. The same small dent on the left side. He had not opened it in several years. Everything in it had been where it needed to be, and so he had let it stay. He got up and took the box down from the shelf. He set it on the table and opened the latch. The trust deed was on top in its original envelope, the paper holding its shape after 54 years, the way good paper does, when it has been kept dry and still. Below it was Harlan's survey notebook from 1929, the handwritten diagrams of the water table mapping he had done before planting. Below that was a smaller envelope, cream-colored with a single line written on the front in Harlan's hand. The ink had darkened over the decades, but the letters were still clear. It said, "For the bank when they come." Walter looked at that line for a long time. He had never opened the envelope. He had been aware of it every time he had opened the tin box over the years, but Harlan had not told him to open it, and so he had left it. It had the quality of something that was waiting for its proper moment. He thought about Harlan in 1931, walking into the water district office with a hand-drawn diagram that no private farmer had ever brought in before. He thought about Harlan sitting across this table in 1970 with his hands flat on the surface. He thought about what Harlan had said about banks and courts and lawyers taking their portion, and how Harlan had moved to prevent it 40 years before the moment it was being attempted. Walter set the cream envelope back in the tin box without opening it. That was for Sunday. That was for when Nathan was there. He closed the latch. He put the box back on the shelf. He went to bed. Outside, the March wind moved through the almond rows on the east section. The trees were in their early blossom period, the white flowers just beginning to open along the branches. The same variety Harlan had planted 90 years ago in soil he had spent 2 years learning before he put a single root into the ground. The irrigation lines ran beneath them in the pattern Harlan had calculated from his Louisiana knowledge, and his Fresno County observations the same pattern Walter had maintained and extended for 50 years. 812 acres. 3 generations. A tin box on a kitchen shelf with a cream envelope inside it that said, "For the bank when they come." Harlan Briggs had known they would come eventually. He had simply made sure that when they did, the answer was already written down and waiting. Sunday came cold and clear, the way March mornings in the San Joaquin Valley sometimes do, the kind of cold that burns off fast once the sun clears the Sierras, but sits heavy on the ground until it does. Nathan drove down from Sacramento alone. Joel was already at the farmhouse when he arrived. His truck parked at the side of the house the way he always parked it, close to the barn wall. Out of habit, Walter had the tin box on the kitchen table. Coffee was made. He had not opened the box yet. He had waited. The three of them sat down. Nathan had been a civil engineer for 22 years. He had built his career around the understanding that systems fail in predictable ways if you know where to look, and that the most dangerous failures are the ones that look like routine operation, right up until the moment they are not. He had spent the drive from Sacramento thinking about Preston Vance the way he thought about structural problems, not with emotion, with sequence. What did Vance do? When did he do it? What did he expect to happen next? Walter opened the tin box. He took out the trust deed and set it aside. He took out Harlan's survey notebook and set it beside the deed. Then he took out the cream envelope with Harlan's writing on the front and placed it in the center of the table between the three of them. For the bank when they come. Joel leaned forward and read it. He looked at Walter. He said, "Did you know about this?" Walter said, "I knew it was there. I never opened it. Harlan did not tell me to open it, so I left it." Nathan said, "How long has it been in there?" Walter said, "Since before I can remember. It was in the box when Harlan gave me the box in 1970. I assume he put it there sometime before that." Nathan said, "Open it." Walter picked up the envelope. The paper had gone the color of old cream, not yellow, exactly something between. He opened the flap carefully. Inside were two documents folded together. The first was a single page on Fresno County Water District letterhead, dated March 14, 1931. The second was a 3-page handwritten letter in Harlan's careful block, printing the same hand as the survey notebook. Walter unfolded the Water District document first. He read it slowly. He passed it to Nathan. Nathan read it twice. He set it down. He looked at the kitchen wall for a moment, the way he looked at structural drawings when something did not match his initial calculation. Not with surprise exactly, but with the particular attention of a man recalibrating. He said, "Priority number 3, county-wide." Walter said, "That is what I remembered him saying. I did not know the clause about reversion." Nathan read the relevant section aloud. "If the Briggs property is transferred through any means other than voluntary sale negotiated directly by the registered trustee, or through inheritance as defined in the Briggs Family Trust instrument, all water access rights and priority status granted under this agreement shall revert immediately and permanently to the Fresno County Water District and shall not transfer with the land title to any acquiring party." The kitchen was quiet. Joel said, "So if someone takes the land by force," Nathan said, "or through a fraudulent proceeding, or through a court order obtained under false pretenses, the water stays with the county. It does not go with whoever takes the land." Joel said, "And without the water." Nathan said, 812 acres of San Joaquin Valley almond orchard. Without senior water rights in a drought cycle is not worth $6 million. It is worth considerably less. Depending on what someone planned to do with it, it might not be worth much at all. Walter said, "Read the letter." Nathan unfolded Harlan's handwritten pages. The paper had held its texture across the decades, the writing dense and deliberate, each line spaced with the care of a man who did not waste anything, including paper. Harlan had written the letter in 1968, 2 years before he signed the trust deed. He had addressed it to whoever was reading it, which he said he expected would be a member of his family at some future point when the banks came looking at the land. He had written that he had no specific knowledge of when or how they would come, but that he had watched enough men lose land they had built to know that the manner of loss usually involved institutions that understood the value of the land better than the family did and moved to acquire it through processes the family did not fully understand until it was too late. He wrote that the water rights agreement was the most important document in the tin box, more important than the deed in one specific way. The deed established what the land was. The water rights established what the land was worth to anyone who wanted it for large-scale agriculture or development. Any institution that moved against the land without knowing about the water clause would be moving against something that could not give them what they expected to receive. He wrote, "I put this letter here because I will not always be present to explain it. You will need to understand what you have before anyone else does. Knowledge of what you hold is the only defense that cannot be taken away before you use it." He had signed it. Harlan Briggs, February 3rd, 1968. Walter sat back in his chair. He was quiet for a moment. Outside, the February cold had begun to lift, and the early light was reaching the top of the almond rose on the east section, the blossoms catching it white and pale against the brown of the bare branches below. He said, "He wrote it 6 years before I ever thought to worry about any of this." Nathan said he wrote it because he had already thought about it. Nathan called Carol Ewan from the kitchen table, while Walter refilled the coffee and Joel stood at the window looking at the orchard. He described the water rights document in detail. He read her the reversion clause. Carol was quiet for several seconds. She said, "Nathan, do you know what Ridgeline Capital is?" He said, "No." She said, "They are a private agricultural investment fund based in San Francisco. They have been acquiring farmland in the Central Valley for the past 3 years. Large parcels, legacy operations, primarily from elderly owners. They have closed 14 transactions in Fresno and Tulare counties in that period. Their typical acquisition price runs 20 to 30% below current agricultural market value." Nathan said, "How do you know about them?" She said, "Because 2 of those 14 transactions were clients of mine, both elderly. Both had held their land for multiple generations. Both received offers they described as arriving out of nowhere, with legal arguments attached, suggesting their ownership documentation had technical deficiencies." Nathan said nothing for a moment. Then he said, "Vance, Carol said I have not been able to establish a direct connection, but the timing of their offers and the nature of the documentation challenges are consistent with someone providing them inside information on account ownership and asset status." Nathan said, "The 2022 assessment Vance filed internally. If he shared that data with Ridgeline," Carol said, "that would be a violation of the Gramm-Leach-Bliley Act, among other things. It would also explain why Ridgeline has been so precise in targeting legacy trusts with elderly trustees. They are not finding these properties through public records alone." Nathan said, "I need you in Fresno this week." Carol said, "I will be there Wednesday." After he hung up, Nathan sat at the table. Walter was looking at him. Joel had turned from the window. Nathan said, "There is more going on than a compliance flag." He told them what Carol had said about Ridgeline Capital. He told them about the 14 acquisitions. He told them about the clients of Carol's who had received offers with legal challenges attached. Joel said, "So Vance was selling information to them." Nathan said, "That is what it looks like." Walter said, "And they were going to buy the land at a discount once they had the documentation challenge in place." Nathan said, "Yes." Walter said, "Without knowing about the water." Nathan said, "Without knowing about the water." Walter looked at the cream envelope on the table. He looked at it for a long time. He said Harlan would have appreciated that. That Sunday afternoon, Walter drove over to see Dale Hutchins. He had been thinking about Dale since Nathan had mentioned the 14 acquisitions. Dale was 72 years old, the same age as Walter, and had farmed citrus on 340 acres 4 miles north since 1979. They had known each other for 40 years, in the way neighboring farmers know each other, which is not always with great frequency, but always with the understanding that the land connects you to someone in a way that other kinds of connection do not. He did not call ahead. He drove over and pulled into Dale's yard and found him at the side of his barn, replacing a hydraulic line on his old disc harrow. Dale wiped his hands on a rag and looked at Walter the way a man looks at someone who is driven over unannounced, which in farming country usually means something is happening. Walter said, "Has the bank been in contact with you lately?" "Coastal Western." Dale set the rag down. He said, "About a year ago. They called asking about my account documentation. Said they needed to verify some trust paperwork. I told them I would get back to them, and then I did not, and they did not call again." Walter said, "Did they send anyone out?" Dale said no. "Just the one call. I figured it was one of those things where they fish, and if you do not bite, they move on." Walter said, "What is your trust situation?" Dale said, "Father set it up in 1961. Land and water both. Same kind of arrangement you have, more or less." Walter said, "Have you had any contact from a company called Ridgeline Capital?" Dale's expression shifted in a way that answered the question. Before he spoke, he said, 3 months ago. Letter came offering to buy. Price was low, about 30% below what the land is worth. And there was a legal opinion attached saying my 1961 trust deed had documentation issues under current California law." Walter said, "Did you respond?" Dale said, "I threw it away. I did not take it seriously." "Walt, what is this?" Walter told him. He told him about his own account hold, about Vance, about the 2022 internal assessment, about what Carol Ewan had found regarding the 14 acquisitions. He told Dale about the water rights document and the reversion clause. Dale stood very still for a while. The hydraulic line was half replaced, and the disc harrow sat with its frame tilted at an angle behind him. He looked like a man absorbing something large by not moving. He said, "They came for both of us." Walter said, "I think they came for more than both of us. I think we need to find out how many others." That was how they spent the following 3 days. Walter drove. Dale made calls. Between them, they identified 5 other families in Fresno and Tulare counties who had received either a call from Coastal Western about trust documentation or a letter from Ridgeline Capital with an acquisition offer, or in 3 cases, both. All of them were over 65. All of them had held their land for multiple decades. All of them had dismissed the contacts as nuisances without understanding the pattern. The 7 families together held a total of 4,200 acres of agricultural land in the San Joaquin Valley. At current agricultural market values, the combined worth was slightly above $28 million. Carol Ewan arrived in Fresno on Wednesday morning. She sat at Walter's kitchen table with the tin box open in front of her and spent 40 minutes reading through everything in it without speaking. Nathan sat across from her. Walter stood at the counter with his coffee. Joel was outside checking the irrigation pressure on the north section, which had been running low since the previous week. When Carol finished reading, she set the water rights document down separately from the others. She said, "The reversion clause is enforceable. I want to be clear about that before anything else. This is not a historical curiosity. Fresno County Water District is still the administering authority. This agreement is still active. If anyone acquired this land through any of the mechanisms described in the clause, they would take title to 812 acres with no senior water rights in a county where senior water rights are the difference between a viable agricultural operation and an expensive piece of dirt. Nathan said, would Ridgeline know that before they moved to acquire? Carol said, not from the assessor records. Water rights priority agreements from 1931 are not uniformly digitized. They exist in county archive files that require physical retrieval. Anyone doing a standard due diligence search on this property would find the deed, the trust instrument, and the county assessor's current valuation. They would not necessarily find a handwritten agreement from the district office 93 years ago. Walter said, what is the value of the property to them without the water? Carol said, Ridgeline's model appears to be acquiring large agricultural parcels at below market prices, and then either leasing them to corporate farming operations or rezoning them for mixed development, where water access is handled through municipal connections rather than senior rights. For the development scenario, senior water rights are not critical. For the agricultural lease scenario, losing priority 3 county-wide is significant. It would affect what Ridgeline could charge a tenant and therefore what the land is worth to them as an investment. She paused. She said, but the more relevant question right now is what Vance gave them and when he gave it. She laid out what she had been able to piece together from the documents Angela Carver had sent. Vance had accessed Walter's account records internally in April 2022. He had filed the estate proceeding inquiry with the county assessor in June 2022. The internal assessment placing a current market value on the Briggs property had been completed in August 2022. Ridgeline Capital had made their first acquisition in Fresno County in October 2022. The timing was a straight line, Nathan said. So he ran the assessment, established the value, and then the acquisition started 2 months later. Carol said, that is the sequence. Whether that sequence constitutes a violation of the Graham-Leach-Bliley Act depends on whether we can demonstrate that Vance transferred protected financial information to Ridgeline. The pattern is suggestive. Pattern is not proof. She said Sandra Oaks may be the proof. Nathan said, the teller. Carol said, the branch employee who noticed Farrell bypassing standard compliance procedure and calling someone above him directly. If Vance accessed Walter's account from the San Francisco office, there will be an access log. If Oaks photographed that log or can direct us to where it exists within the system, we have documentation of unauthorized access to a customer's trust account by an officer of the bank who subsequently had a financial relationship with a party that moved against that same customer's property. Nathan said, you need to talk to her. Carol said, I need you to talk to her first. She called you voluntarily. She trusts you more than she trusts a lawyer she has never met. Nathan called Sandra Oaks that evening. She answered on the second ring. She sounded like someone who had been waiting for the call and had not entirely decided whether she was glad it came. He said, Sandra, I need to ask you something directly. What you photographed on that screen. The access log showing Vance's account, accessing my father's records from San Francisco. Do you still have it? She was quiet for a moment. Then she said, yes. He said, I'm going to connect you with an attorney named Carol Ewan. She handles trust and estate cases. She is not representing the bank. She is representing my father. What you have may be important, but I need you to understand that sharing it with us may complicate your employment situation. Sandra said, I have been thinking about that for 2 weeks. Since the day I watched Farrell pick up that phone and call someone whose name was not on any compliance procedure I've ever seen in 4 years at this branch. She said Mr. Moe had been coming to that counter since before I was hired. I processed 3 of his deposits myself. He wore the same kind of shirt every time. He always said thank you when I handed him his receipt. She stopped. Then she said, "What they are doing is not right. I do not have a fancy way to say it. It is just not right." Nathan said, "No, it is not." The following morning, Sandra sent Carol Ewan a secure message with 3 attachments. The first was a screenshot of the internal access log showing Preston Vance's San Francisco user credentials, accessing Walter Briggs's account records on 4 separate dates in April and June of 2022. The second was an internal email chain from June 2022, in which Farrell had been copied on a communication from the trust department flagging the Briggs account for, and these were the precise words used long-term estate preparation monitoring. The third was a document Sandra had not initially understood, but which Carol recognized immediately. It was a non-disclosure agreement that Farrell had been asked to sign in July 2022 regarding client accounts under what the document called Enhanced Trust Review Protocol. Carol called Nathan after reviewing the attachments. She said Vance did not act alone. Farrell knew. Nathan said, "How much trouble is Farrell in?" Carol said, "That depends on whether he was a participant or whether he was told to sign something and did not ask enough questions. But the NDA itself is significant. Banks do not ask branch managers to sign non-disclosure agreements about individual client accounts under normal compliance procedures. Someone wanted Farrell to stay quiet about specific accounts. That is not standard. That is deliberate concealment." She said, "I am filing with the California Department of Financial Protection and Innovation tomorrow morning, and I am sending a referral to the FBI Financial Crimes Unit. The DFPI can move quickly on a complaint with this level of documentation. The FBI will take longer, but the referral itself changes Coastal Western's exposure calculation. Once the FBI has a file number on this, the bank's legal team will be in settlement mode within weeks." Nathan said, "What does my father need to do?" Carol said, "Nothing yet. Tell him to go to work." Nathan called Walter and told him what Carol had found and what she was doing. Walter listened. When Nathan finished, Walter said, "What does she need from me?" Nathan said, "Nothing right now. She said to go to work." Walter said, "The north section irrigation pressure is still low. Joel thinks it is the secondary valve on the line from the pump house. I'm going to look at it in the morning." Nathan said, "Dad." Walter said, "The trees do not know about any of this. They still need water." He hung up. 2 days after Carol filed with the DFPI, a letter arrived at the Briggs farmhouse. It was from Ridgeline Capital. The letter was written on heavy cream stock with an embossed letterhead, and it was addressed to Walter Briggs, trustee. The offer was $3,100,000 for the Briggs property, described as a competitive market offer, reflecting current agricultural land valuations in Fresno County. The letter included a 2-page legal opinion from a firm called Mercer and Associates, asserting that the 1970 Briggs trust deed contained documentation deficiencies under California probate code amendments enacted in 2019, and that the validity of the trust instrument was therefore subject to challenge. The offer had a deadline, 48 hours. Joel found the letter on the kitchen counter when he came in from checking the north section valve. He read it. He read the legal opinion. He set it down and looked at it the way you look at something that has crossed a line you did not previously know existed. Walter came in from the east section, and Joel handed him the letter without saying anything. Walter read it. He read it the way he read anything important, slowly and completely without skimming. He read the legal opinion. He looked at the embossed letterhead and the signature at the bottom, and the 48-hour deadline stamped in bold at the top of the second page. He folded it. He put it in his shirt pocket. Joel said that legal opinion is not accurate. The 2019 amendment does not apply to trust instruments recorded before 1985. Walter said, I know. Joel said, Dad, they are trying to scare you into selling in 2 days. Walter said, I know what they are trying to do. He was quiet for a moment. Then he said, Joel, call your brother. And call Dale. He went to the shelf and took down the tin box and brought it back to the table. He set it down and opened the latch and looked at the cream envelope inside the one with Harlan's writing on the front. He did not take it out. He just looked at it for a moment. Then he picked up his phone and called Carol Ewan. When she answered, he said, they sent an offer. $3,100,000 with a 48-hour deadline and a legal opinion saying the trust deed has documentation problems. Carol said, when did you receive it? He said, today. Joel found it on the counter. I do not know when it arrived. She said, do not respond. Do not acknowledge receipt of the offer in writing or by phone. I'm going to call their counsel this afternoon. In the meantime, tell me the name on the legal opinion. He looked at the letter. He said, Mercer and Associates. Carol was quiet for just a moment. Then she said, Walter, I am going to tell you something, and I need you to stay calm. He said, I am calm. She said, the attorney who signed that opinion. His name is listed as Daniel Kress. Before he joined Mercer and Associates 4 years ago, Daniel Kress was a staff attorney in the trust department at Coastal Western Bank. He worked there for 3 years. His direct supervisor during that period was Preston Vance. Outside, the wind moved through the almond blossoms on the east section. The bees that Walter had brought in for pollination worked through the trees in the late afternoon light, moving from flower to flower, with the particular indifference of creatures that do not know or care about anything except the work directly in front of them. 812 acres. The water running beneath it in the aquifer that Harlan had mapped by hand in 1929 and 1930. Walking the land in every season. Digging test wells recording what he found in a notebook that now sat in a tin box on Walter Briggs's kitchen table. The cream envelope with its line of careful block printing. For the bank when they come. They had come. And Harlan had known 56 years before this particular afternoon exactly what they would need when they did. Carol Ewan spent that evening and most of the following morning building the case file. She had done this kind of work for 30 years, and she had learned that the moment an institution realized its exposure was larger than it had calculated was always the moment the dynamic shifted. The question was never whether that moment would come. The question was whether you had enough in your hands when it did to make the shift permanent. By Thursday morning, she had enough. She called Nathan at 7 and told him to arrange for Walter and Joel to be in Fresno by 10. She called Dale Hutchins herself and asked him to come and to bring whatever documentation he had from the Ridgeline letter and the Coastal Western call from the previous year. She had already been in contact with 2 of the other 5 families. They could not all be present, but they had signed authorization letters allowing Carol to represent their interests in the initial meeting. Nathan drove down from Sacramento that night and slept in his old room at the farmhouse for the first time in 4 years. In the morning, he found Walter already at the kitchen table with coffee made and the tin box open in front of him. Walter had taken everything out and laid it flat on the table. The trust deed, the survey notebook, the water rights agreement, the cream envelope, its contents refolded and replaced, but the envelope itself left open. Nathan sat down. He did not say anything for a moment. Then he said, "How are you doing?" Walter said, "The north section valve is fixed. Joel got it running yesterday afternoon. Pressure is back to normal." Nathan looked at his father. Walter was looking at the documents on the table, not at Nathan. His hands were flat on the surface the way Harlan's hands had been flat in 1970 when he sat across this same table and explained what he had done and why. Nathan said he built something that lasted 95 years. Walter said he built it to last longer than that. The resolution meeting was held not at the Coastal Western branch on Elm and Covington, but at a conference room in a law office building in downtown Fresno that Carol Ewan used for mediations. She had requested neutral ground, and Coastal Western's counsel had agreed, which Carol took as confirmation that the bank had already assessed its position and decided that the cost of prolonged litigation exceeded the cost of a negotiated resolution. Preston Vance arrived at 9:55 with 2 attorneys from Coastal Western's legal team and a compliance officer named Richard Holden, who had flown in from the San Francisco headquarters that morning. Vance was 38 years old and wore a suit that fit the way suits fit men who think about how their suits fit. He carried a leather portfolio and moved through the lobby of the building with the practiced ease of someone who had sat across tables from people in difficult situations many times and had come out the other side without significant damage. He stopped when he came through the conference room door. Walter was at the far end of the table. Nathan sat to his left. Joel to his right. Dale Hutchins sat 2 seats down with a manila folder on the table in front of him. Carol Ewan sat at the near end with a stack of documents organized in labeled sections. Beside her sat a woman Vance did not recognize, who was introduced as a representative from the California Department of Financial Protection and Innovation. She had a notepad and a recorder on the table, and she did not smile when she was introduced. Marcus Webb arrived 2 minutes after Vance. Webb was 42, the acquisitions director for Ridgeline Capital, and he had driven down from San Francisco, expecting to observe a settlement discussion that would clear the final legal obstacles to the Briggs acquisition. He had the quiet confidence of someone who had closed 14 transactions in the past 3 years and did not anticipate that number 15 would be different. He sat down. He looked at the woman from the DFPI. He looked at Carol's document stack. He looked at Walter Briggs in the flannel shirt at the far end of the table. He did not look entirely comfortable after that. Carol opened without preamble. She said, "I want to establish the factual record before we discuss resolution. I'm going to present a timeline, and I am asking everyone in this room to let me complete it before anyone responds. After that, we can discuss what Coastal Western and Ridgeline Capital would like to do." No one objected. She began with April 2022. Preston Vance, operating from Coastal Western's San Francisco Trust Department office, accessed the account records of Walter Briggs on 4 separate occasions. She laid the access logs on the table, copies for everyone present. She described what the logs showed: Vance's user credentials, the timestamps, the specific account fields accessed, which included the trust instrument, referenced the property description, and the assessed value notation. Vance's lead attorney started to say something. Carol held up one hand and kept talking. In June 2022, she continued. Coastal Western's Trust Department filed an inquiry with the Fresno County Assessor's Office characterizing the Briggs property as being subject to an estate proceeding review. The inquiry was filed while Walter Briggs was alive and had not initiated any estate proceeding. She laid the assessor inquiry on the table. She laid the assessor's response, which had been filed in the bank's internal records. She laid the internal email from June 2022, in which Farrell had been copied on a communication describing the Briggs account as flagged for long-term estate preparation monitoring. She laid the non-disclosure agreement Farrell had signed in July 2022. She said in August 2022, an internal property assessment was completed, placing a market value on the Briggs property. In October 2022, Ridgeline Capital began its acquisition program in Fresno County. She looked at Marcus Webb. She said, between October 2022 and March 2024, Ridgeline Capital made acquisition offers to 7 agricultural landowners in Fresno and Tulare counties. All 7 were over the age of 65. All 7 held legacy trust instruments. All 7 received legal opinions challenging the validity of their trust documentation. 6 of those legal opinions were signed by Daniel Kress of Mercer and Associates, who prior to joining Mercer and Associates worked as a staff attorney in Coastal Western Bank's trust department, under the direct supervision of Preston Vance. Webb looked at the table. He looked at the DFPI representative. He looked at his own attorneys and received nothing useful from their expressions. Carroll said, "I have documentation for each of these points. Copies are in front of everyone at this table. I am now going to ask Walter Briggs to put something on the table that I believe will significantly clarify the financial reality of the situation for Ridgeline Capital specifically." She looked at Walter. Walter had been sitting still through the entire presentation. He had not written anything down. He had not leaned forward or shifted in his chair. He looked the same as he had looked walking into the Coastal Western branch on that Tuesday morning in March, with his brown envelope and his polished boots and his 37-year account card. He looked like a man who had already decided what was going to happen and was simply waiting for the appropriate moment to allow it to be understood by everyone else. He reached down to the floor beside his chair and picked up the tin box. He set it on the table. He opened the latch. He took out the water rights agreement, the original on Fresno County Water District letterhead dated March 14, 1931. He unfolded it and laid it flat on the table and slid it to the center where everyone could see it. He did not say anything. He did not need to. Carroll said, "This is the Briggs family water rights agreement with the Fresno County Water District, executed in 1931. Under this agreement, the Briggs property holds priority access number 3 to the Fresno County aquifer system." I'm going to read one clause in particular. She read the reversion clause. She read it slowly and without editorializing. Just the words in the order Harlan and the district engineer had written them 93 years ago. The room was quiet when she finished. She said, "Mr. Webb Ridgeline Capital has invested approximately $14 million acquiring adjacent and surrounding parcels in the section of Fresno County where the Briggs property is located. I have the county recorder's transfer records here." She laid them on the table. She said, "The development model Ridgeline has filed in their preliminary application with the Fresno County Planning Department shows a mixed agricultural and residential development project with projected water supply drawing on the senior aquifer rights in this section of the county. That application is in the public record." She paused. She said, "If the Briggs property were acquired through any of the mechanisms used or contemplated in this situation, including the fraudulent estate proceeding framing used in the June 2022 assessor inquiry or through litigation pressure, based on the false legal opinion issued by Daniel Kress, the water rights under this 1931 agreement would revert to Fresno County. They would not transfer with the land. Ridgeline's development project, as currently filed, cannot proceed without priority access to the aquifer system. Without the Briggs water rights attached to the Briggs land, the $14 million already invested in adjacent parcels supports a development project that cannot be approved as currently structured." Marcus Webb had stopped looking at anyone. He was reading the water rights document. He read it the way a man reads something that is dismantling a significant portion of his professional situation in real time. His expression was not dramatic. It was the expression of someone doing very precise internal arithmetic and not arriving at a number he wanted. One of his attorneys leaned toward him and said something quietly. Webb shook his head once. Vance had not spoken since entering the room. He sat with his leather portfolio on the table in front of him, unopened. His expression had undergone a visible change between the moment he walked through the door and this moment. The practiced ease had been replaced by something more careful and more contained. He looked like a man measuring every possible response and finding none of them satisfactory. His lead attorney said, "We would like a recess to confer with our clients." Carol said, "Of course. I would like to note for the record that the hold on Walter Briggs's savings account has been in place for 3 weeks. The $600 he came to withdraw on March 5th was for an irrigation pump repair. The pump has since been repaired by other means, but the account remains frozen. We will expect that to be addressed in whatever proposal you bring back to this table." The recess lasted 40 minutes. When Vance's attorneys returned, Vance was not with them. His lead attorney said Vance was participating by phone. This was, Carol noted to herself, a lawyer managing a client's physical presence in a room where his physical presence was now a liability. She said nothing about it. The proposal Coastal Western's attorneys presented was structured in 4 parts. First, immediate release of the hold on Walter's account, with written confirmation of the account's clear status delivered that afternoon. Second, a written formal acknowledgement that the June 2022 assessor inquiry had been filed without the knowledge or authorization of Walter Briggs or the trust beneficiaries, and that the characterization of the Briggs account as subject to an estate proceeding had been factually incorrect. Third, financial compensation for breach of fiduciary duty, unauthorized access to trust account records, and the direct costs incurred by the Briggs family in responding to the situation, including legal fees. Fourth, a compliance review of all trust accounts in Coastal Western's California portfolio, flagged under what the bank was now calling the Enhanced Trust Review Protocol, with external auditor oversight, and a report filed with the DFPI within 90 days. Carol read the proposal. She made 2 notes in the margin. She said, "The compensation figure needs to reflect not only the Briggs family's costs, but the impact on the 6 other families who received documentation challenges and acquisition offers that are directly traceable to information originating in Coastal Western's trust department. Those families authorize me to represent their interests in this resolution. They are not filing separate actions at this time in exchange for inclusion in the settlement terms." There was a conversation across the table that Nathan could not fully follow, but could read in outline from the body language. The lead attorney shook his head. His colleague said something. The lead attorney shook his head again, but less definitively. He made a phone call, turned away, spoke for 2 minutes. When he turned back, he said, "We can include the other families within the compensation structure. We will need to verify their documentation." Carol said, "Their documentation is in the folder I am about to slide across this table." She slid it. Then she looked at Marcus Webb. She said, "Ridgeline Capital is not party to this settlement. But I want to be direct about something before this meeting concludes. The 7 families represented in this room and in this file hold a combined 4,200 acres in Fresno and Tulare counties. Each of those properties was approached through a process that originated with unauthorized access to protected financial information. If Ridgeline Capital proceeds with any further acquisition efforts directed at these families or at other legacy trust holders in this region, using information that may have originated through the same channel, the referral already filed with the FBI Financial Crimes Unit becomes significantly more relevant to Ridgeline's own legal exposure." Webb said, "Ridgeline Capital operates within the law." Carol said, "I am certain that is your intention." She said it without inflection. She moved on. The settlement terms were finalized over the following 11 days. Carol negotiated by phone and document exchange. She did not need Walter in a conference room again. He had already done what he needed to do in that room, which was to sit at the end of a table and open a tin box and put a piece of paper on the surface without saying a word. The final terms covered the Briggs family and all 6 other families. The compensation figure was not disclosed publicly, but it addressed legal fees that documented costs of responding to the Ridgeline acquisition pressure, and what Carol described in private to Nathan as a meaningful acknowledgement of the breach itself. Coastal Western's trust department was placed under DFPY monitoring for 18 months. The external audit of trust accounts under the Enhanced Review Protocol identified 11 additional accounts that had been accessed without documented compliance justification. Those account holders were notified. Preston Vance was placed on administrative leave the day after the resolution meeting. He did not return to his position. The bank's public statement said only that he had separated from the company. Farrell was transferred to a non-management role in a different branch. Sandra Oakes was not disciplined. She continued at the Elm and Covington branch, and 3 months after the settlement was promoted to a compliance coordination role that had not previously existed at the branch level. The promotion was not a condition of the settlement. It was a decision the branch's new regional supervisor made after reviewing the situation and concluding that Sandra had identified a problem that the existing compliance structure had missed. Daniel Kress at Mercer and Associates withdrew the legal opinions he had issued regarding the Briggs trust deed and 3 of the other families' documentation within 2 weeks of the resolution meeting. No explanation was given publicly. Carol noted to Nathan that the withdrawal itself was the most legally significant act Kress could perform at that point, as it effectively acknowledged the opinions had been issued without adequate factual basis. She said she expected he would be managing that decision's consequences for some time. Marcus Webb called Carol 3 weeks after the resolution meeting. He said Ridgeline Capital was restructuring its Central Valley acquisition program and would not be pursuing the properties under review. He said it in the measured tone of a man who had spoken with his own legal counsel at considerable length before making the call. Ridgeline's development application in the Fresno County Planning Department was amended 6 weeks later. The amended filing showed a different water sourcing model. The section referencing senior aquifer rights in the Briggs property section of the county had been removed entirely. Nathan called Walter on a Thursday afternoon in late April to tell him the settlement had been finalized. Walter was in the east section. He had been out since early morning checking the canopy on the trees that had come through the late frost the previous week. The blossom period was critical, and a hard frost in the second week after bloom could set the yield back significantly. 3 of the rows on the far east end had taken some damage. Not severe, but enough to watch. He had been watching them. He answered the phone. Nathan said, "It is done. Carol called this morning. Everything is finalized." Walter said, "The terms she described." Nathan said, "All of it, including the other families." Walter was quiet for a moment. He was standing at the end of the damaged rows looking at the blossoms on the affected trees. Some were brown at the edges, but the centers were still viable. He had seen worse come back. He said, "What about Vance?" Nathan said, "Gone from the bank. The DFPI has an open monitoring file. Carol says the FBI referral stays active." Walter said, "And the land." Nathan said, "The trust is intact. Nothing that happened touches the trust instrument. The water rights are documented and on record with the county as of last month." Carol filed a certified copy with the assessor's office to ensure it is in the digital record going forward. Walter said, "Good." Nathan said, "Dad, do you understand what you did?" Walter said, "I went to the bank to get $600. Nathan said, "You held them accountable for an operation that ran for 3 years across 7 families and $28 million in assets." Walter was quiet for a moment. The wind moved through the east section, carrying the smell of almond blossom, the way it always did in April. Sweet and faintly dusty, the smell that had been the smell of this land since 1934. when Harlan planted the first trees. He said Harlan did it. He mapped the water in 1929 and 1930 when nobody asked him to. He signed the agreement in 1931 because he understood what the water was worth. He wrote the letter in 1968 because he understood that understanding would be needed by someone who was not yet old enough to have it. He put it all in that box and told me where the box was. Nathan said, "You kept it for 54 years. Walter said, "That is not a hard thing to do when you know what you are keeping." He ended the call and put the phone in his pocket. He walked back along the east section. The morning light was full now, coming in from the southeast and hitting the canopy at the angle that showed you the true color of the leaves, the deep, healthy green where the irrigation was right, and the slight yellow at the margins where it needed adjusting. He made a note in his head about the third row from the fence line. The drip emitters on that row had been running low for 2 weeks. He had been meaning to check the lateral line pressure on that section. He would do it this afternoon. Joel's truck was parked at the barn when he came back up the access road. Joel was inside working on the disc harrow that had been sitting half-assembled for 2 weeks while everything else had been happening. Walter heard the ratchet turning the precise mechanical sound of something being put back together correctly. He stopped at the barn door. Joel looked up. He read his father's expression. He said, "Done." Walter said, "Done." Joel set the ratchet down. He said, "All of it." Walter said, "All of it." The other families, too. Joel looked at him for a moment. He said, "Are you going to call Dale?" Walter said, "I will drive over later. It is better in person." He went inside and poured coffee and stood at the kitchen counter. The tin box was on the shelf where it had always been. He looked at it. He thought about the cream envelope inside it, the one that Harlan had written and sealed and placed in the box, somewhere around 1968, waiting. He thought about the specific patience that required. Not the patience of waiting for something you hope will happen. The patience of preparing for something you know will happen, and ensuring that when it does, the answer is already in place. Harlan had been 33 years old when he bought this land. He had been 67 when he wrote that letter. In the 34 years between those 2 points, he had built the orchard, raised the family, managed the water, and quietly laid in everything that would be needed by the people who came after him. He had not announced it. He had not explained it to anyone at the time. He had simply done the work and put the results in a green tin box with a small dent on the left side and told Walter where it was. Walter picked up the phone and called the pump repairman. The man answered on the third ring. Walter said, "This is Walter Briggs out on County Road 14. I owe you for the east section pump repair from 3 weeks ago. I was held up getting to the bank. I can bring payment out this afternoon if you will be around." The pump man said he would be there. Walter said, "I appreciate your patience." He hung up. He went to the shelf and took down the tin box. He opened it. He looked at everything inside. The trust deed. The survey notebook with Harlan's careful diagrams. The water table depths recorded in pencil across pages that had held the information for 93 years without failing. The water rights agreement. The cream envelope. He refolded the water rights agreement and placed it back. He put the survey notebook back. He put the cream envelope back. He put the trust deed on top, where it had always been. He closed the latch. He put the box back on the shelf. He stood there for a moment looking at it. The green paint and the small dent and the simple latch that had no lock, because Harlan had never seen the need for a lock on something that was protected by more durable means than metal. It was protected by knowledge, by the habit of keeping things, by the understanding that what you build does not defend itself. You defend it by knowing what it is. Outside, the east section was quiet in the mid-morning. The bees were working. The blossoms on the frost-damaged rose were doing what blossoms do when they are not entirely gone, which is continue. The almond trees on this land had been producing for 90 years. They had come through drought years and flood years and the long years of low prices. When the operating account had been tight through winter and spring, and the only reason to keep going was the understanding that the land itself did not care about any of that. It only responded to what you put into it. Harlan had understood that. Walter had learned it. In 20 or 30 years, if the trees were properly managed and the water rights were maintained and the trust instrument held its shape the way Carol said it would, Nathan's name would be on the trustee line and the land would still be producing. And someone else would be walking these rows in the early morning checking the canopy color and the drip emitter pressure and the condition of the irrigation laterals on the east section. That was the plan. That had always been the plan. Walter picked up his jacket from the hook by the door and went outside. He had work to do before the afternoon. The third row on the east section needed the lateral pressure checked. The drip emitters on the far end had been running low and he had been putting it off, and now there was no reason to put it off any further. He walked out into the morning. The almond rows stretched ahead of him in the light. The same rows Harlan had measured and staked in 1934. Running east to west in the direction that caught the morning sun on the faces of the developing fruit in August, when the hulls were splitting and the harvest crews were coming. 90 years of almonds. 90 years of water pulled from the aquifer that Harlan had mapped by hand before anyone else knew it was there. 812 acres. 3 generations. A tin box on a kitchen shelf. Dale Hutchins was in his own orchard when Walter pulled into the yard that afternoon. Walter got out of the truck and walked through the gate and found him at the far end of the citrus rows, checking the condition of the Valencia oranges that had come through the frost better than the navels. Dale saw him coming and waited. Walter said, "It is settled. All 7 families." Dale took his hat off. He held it in both hands for a moment. He was 72 years old and had been farming this land since 1979, and he had built it the way men build things when they know they are building something they will not live to see finished. He looked out at his citrus rows. He said, "My father bought this land in 1961. He paid $40 an acre. Walter said Harlan paid $11,000 for the whole 812. 1931. Dale said, "They were not going to let us keep it." Walter said, "No." Dale put his hat back on. He looked at Walter. He said, "How did you know to bring that deed to the bank that day in March?" Walter said, "I did not bring it because I knew. I brought it because I was angry. And I wanted the man at the counter to understand that he was not talking to someone with nothing to stand on." Dale said, "And the water rights." Walter said, "That was Harlan. I did not know the detail of the reversion clause. I had not read the agreement since he died. It was in the box, and I knew it was important, and so I kept it there." Dale looked at him for a long moment. He said, "You kept a piece of paper in a box for over 40 years without reading it, and it turned out to be exactly what you needed." Walter said, "I kept it because Harlan told me to keep it." He understood what it was. I trusted that. They stood in the citrus rows for a while without talking. The late April afternoon was warm the way the valley gets warm in late spring. A dry, pleasant heat that does not yet have the weight of summer in it. The oranges on the trees were 2 months from harvest, still holding their deep green, the fruit set heavy on the branches from the winter rains. Dale said, "I am going to have my attorney review everything in my trust documents this week. The whole file. Everything my father left." Walter said, "That would be a good thing to do." He drove home in the early evening. He came in the back door and hung his jacket on the hook. He washed his hands at the kitchen sink. He made coffee because it was what he did when he came in from the fields, regardless of the time of day. He stood at the counter and looked at the tin box on the shelf. He thought about calling Nathan. He decided Nathan knew what he needed to know. He thought about calling Joel. Joel's truck had been gone when he came back up the access road. Joel was living his life the way sons do. He sat down at the kitchen table with his coffee. The kitchen was quiet. The late light came through the window over the sink and moved across the table the way it did every evening at this time, crossing the surface from right to left as the sun dropped. It had crossed that table for as long as Walter could remember. His whole life had been measured partly by that movement of light across this surface. He thought about the morning in March when he had driven 40 minutes to the bank and been told he could not have $600 that was his. He thought about the drive home, the engine ticking in the parking lot, the building behind him with 37 years of his money in it. He thought about the evening he had taken the tin box down from the shelf and opened it and found the cream envelope sitting where it had always been, waiting for him to finally need what was inside it. He had not known in that moment what the full shape of what was coming would be. He had only known that Harlan had prepared for it and that the preparation was inside the box. That had been enough to feel. He sat in the quiet kitchen for a while longer. Then he got up and went to the refrigerator and found what he needed for dinner and started making it, because the day was not done and the evening required eating the same as any other evening, and the work of tomorrow would start early, and the east section lateral pressure still needed checking in the morning, and the trees did not know or care about any of what had happened. They only knew what they always knew. What you put in the land returns. Harlan had known that in 1929 when he came from Louisiana with $200 and a knowledge of water. Walter had known it his whole life. He stood at the stove and cooked his dinner, and the evening settled in over the valley, over the almond rows and the citrus groves and the deep water running in the dark beneath the soil. The same water that had been there when Harlan walked the land in 1929 and counted the test wells and drew the diagrams and understood what he had before anyone thought to tell him. The tin box sat on its shelf. The latch was closed. Everything inside it was exactly where it needed to be.